After the performance of the consideration, so the contract come to an end, that we call it as a discharge by performance. Either it is a promisor or it is a promisee. The contract had been broken, the promise had been broken, that we call it as a breach of contract. Where the new agreement takes place, the old agreement get expired. So this we call it as a discharge by agreement. Hello everybody, a warm welcome to one and all. I am Mr. Hemant Kumar from the Department of Commerce and Management, Vidhyaashram First Grade College, MYSURU, the Temple of Excellence. In today's session, we are going with Business Regulatory Framework. This is session 3 of Unit 1, that is Indian Contract Act 1872, that is for 4th semester BCom students. This is agenda of today's session. We are going with the concept of discharge of contract, concept of breach of contract, and also remedies for breach of contract under section 73 and 75. So, discharge of contract. So, what is this discharge of contract? The name itself, it is going to say that, so the contract is going to come for an end, that is discharge of contract. Okay. So, discharge of contract means termination of the contractual relationship between the parties. As I said, so the contract is going to come for an end, that we call it as a discharge of contract. In simple words, discharge of contract means that contract comes to an end, that is discharge of contract. So, discharge of contract is going to happen in different ways. It is classified into 6 categories, that we call it as a modes of discharge of contract. In 6 ways we can discharge the contract. It totally depends upon the situation, it totally depends upon the circumstances, it totally depends upon the product or the thing based on the consideration, right? So, number 1, discharge by performance, discharge by agreement, discharge by lapse of time, discharge by operation of law, discharge by impossibility of performance, and also discharge by breach of contract. Okay, so these are all the 6 methods where we are going to discharge the contract. Okay, we shall go with the discharge of the contract individually, right? So, modes of discharge of contract, discharge by performance. Okay, so please be very careful, students. Okay, so the topic that is very important in the exam point of view, we can expect this question for 15 marks in your final exam. Okay, so discharge by performance, very simple. The contract get discharged after the performance of the specified task, both with promisor and promisee. Okay, say for an example, so there is a contract between the 2 parties, Mr. A and Mr. B. Okay, so Mr. A is selling his site to Mr. B as a consideration of 1 lakh rupees. Okay, so what happens after the sales get happen? Okay, so he registered site for Mr. B. Okay, he also transferred the amount. Okay, both the consideration had fulfilled. Okay, so the contract get end. This kind of a winding up of contract, we call it as a discharge by performance. After the performance, what is the performance that is required? Okay, he should transfer the site for Mr. B. Okay, it is over. Again, B should transfer money to Mr. A, that is consideration 1 lakh rupees. Okay, so that is also over. So after the performance of the consideration, so the contract come to an end, that we call it as a discharge by performance. Second one, discharge by agreement. Okay, so very simple. All the things that is going to happen as a contract, it is a mutual agreement between 2 parties. But when it comes in terms of a discharge by agreement means, okay, so I explain by giving a beautiful example. Okay, so Mr. A is a owner. Okay, so Mr. A is a owner of a flat. Okay, so Mr. B is a tenant to Mr. A. Okay, so Mr. B is a tenant to Mr. A. Mr. B have to pay 10,000 rupees every month as a rent. Okay, so he have to pay 10,000 rupees as a rent to Mr. A every month. Okay, so what happens? agreement is valid till 11th month. After 11th month, they have to renew the agreement, right? So what happens after the completion of the agreement? So they are supposed to change the agreement, means they are supposed to change the terms, means the rental will be increased by 10%. So it is now 10,000 rupees. So next month it will be 11,000 rupees. Okay, so the updated agreement. So what happens? So they had updated the agreement, means the old agreement is invalid. Okay, so the old agreement will be terminated. That we call it as a discharge by agreement. In simple words, where the new agreement takes place, the old agreement get expired. So this we call it as a discharge by agreement. This process we call it as a discharge by agreement. Discharge of contract by lapse of time. So I will give you one beautiful example. Okay, so Mr. A and Mr. B. Mr. A is ready to sell his property to Mr. B for the consideration of 10,000 rupees. Okay, Mr. B also had agreed, okay, to pay 10,000 rupees. Okay, so what happens? He agreed to pay 10,000 rupees on March 10th, right? So dated March 10th, he is supposed to pay 10,000 rupees and collect his property, means Mr. A property to Mr. B, right? So what happens? March 10th is already over. Okay, so Mr. B, he refused to purchase the property of Mr. A. Okay, so the time is over, right? So what happens? Mr. A have the complete right to sue against Mr. B under the court of law, because before 10th of March, C had offered Mr. A saying that I am ready to pay you 12,000 rupees for the same property. Just because of the reason he had been agreement with the Mr. B, he refused to give his property to Mr. C. Okay, so he have complete rights on Mr. B under the court of law. That we call it as a discharge of contract by lapse of time. The time is already over, but he can claim against Mr. B. The Mr. B is liable for the compensation for Mr. A. Discharge by operation of law. Okay, so here in these terms, okay, there is no mistake with Mr. B, neither with Mr. A. Okay, so according to the law, the contract must get end. Under which circumstances this is going to happen? Okay, I will give you one example. Fine. Mr. A have a contract with Mr. B saying that I am going to sell my property. Okay, so and Mr. B also agreed to purchase his property. Okay, so there is a mutual agreement between Mr. A and Mr. B. After few days of agreement, before the performance of the specified task, okay, so what happened? The B get expired. Okay, so B get expired. So what happened? Automatically under the court of law, when there is no availability of a promisee, okay, so what happens? The agreement or the contract get closed. That we call it as a discharge by operation of law. There is no mistake from the end of Mr. A. There is no mistake from the end of Mr. B. The contract, what happens? It get winded. Okay, again. So second circumstance, okay, what happens? Again, there is an agreement between Mr. A and Mr. B. Mr. B become insolvent. He could not able to pay the money. So what happened? So he is declared as a insolvent under the court of law, unfortunately. So what happened? The agreement or the contract came to an end. So that contract we call it as a discharge by operation of law. Discharge by breach of contract. Okay, so what is this discharge by breach of contract? So if a promise is broken with any one of the parties or with both the parties, so that we call it as a breach of contract. Say for an example, there is a promise that is made by Mr. B to Mr. A. If that promise is broken by either Mr. B or Mr. A, that we call it as a discharge by breach of contract. Okay, so the difference between the discharge by breach of contract or the breach of contract and discharge of contract is this: discharge of contract is going to happen only after the performance of the specified task. Breach of the contract is going to happen before the performance of the task and they fail or they refuse to perform the specified task that had been agreed. That we call it as a breach of contract. Okay, I will give you best example. Okay, so what happens? So there is agreement with Mr. A and Mr. B. Okay, so beginning Mr. B had agreed with the contract and he is okay with all the things that had been considered. Okay, later B change his mindset and say I'm not okay with the thing, then what happens? There will be a breach of contract. The contract is going to end in that circumstance. Discharge by impossibility of performance. Okay, so there are few contracts that is going to happen impossible to perform at the end of the day. So what happens? Knowingly the people get entered into the contract knowing that it is highly impossible to perform the specified task. Okay, so at the end of the day what is going to happen? So it is going to end up. Okay, so say for an example, there is a contract between Mr. A and Mr. B. Okay, so Mr. A say that if you give me 10,000 rupees, I am going to find the treasure and I am going to hand over to you. Right? So practically it does not happen actually, but knowing that practically it does not happen, both the parties had entered into a contract. So it is a void contract according to the law. Hence we can say that, so this is discharged by impossibility of performance. Finally, he could not able to perform. So how come he know about the availability of the treasure? Yes or no? So if there is a treasure, why he is going to disclose Mr. B saying that I am going to find the treasure? He may utilize the complete treasure and become rich, no? Right? So it is a way how the things are going to happen. And even B also knowing that he cannot find the treasure, he entered into a contract, and B does not have any right to sue against Mr. A because it is a void contract. Again, concept of breach of contract. Okay, so it is also a very important concept. Okay, when a promise or an agreement that is broken with any of the parties, that we call it as a breach of contract. Either it is a promiser or it is a promisee. The contract had been broken, the promise had been broken, that we call it as a breach of contract. None of the parties keep till end of the agreement, nor they fulfill the obligation, nor the promiser, nor the promisee. This breach of contract is classified into two categories. One is actual breach, second one is anticipatory breach. So as I said, so breach of contract is classified into two categories: anticipatory breach and actual breach. Okay, so anticipatory breach means breach before the due date. Okay, so I will give you example. So there is an agreement between Mr. A and Mr. B. Okay, so agreement, Mr. A is ready to sell his property to Mr. B for the consideration of 1 lakh. Let me consider 1 lakh rupees. Okay, so for 1 lakh rupees, Mr. A is ready to sell his property on 1st of April, right? So on 1st of April, he agreed to hand over his property to Mr. B for the consideration of 1 lakh rupees. Anticipatory breach means breaching up of the contract or the agreement before the specified period of time that had been specified, 1st April. Okay, so there is an agreement between A and B. So saying that he is supposed to purchase the property of Mr. A. Due to certain reasons, Mr. B refused to purchase the property of Mr. A, and also he conveyed him on 20th March. Okay, so before the period of performance, he had informed Mr. A saying that, so I am not interested in your property, I am looking towards some other property. Okay, so what happened? This kind of breach of contract means he is not willing to purchase his property means, so it is a breach of contract. But this kind of breach of contract, we call it as an anticipatory breach of contract. The name itself, it is going to say, so breach before the due date. The due date is 1st April to pay the amount and collect his property. Okay, so before this date, he had conveyed or communicated to Mr. A saying that I am not interested in your property. You can say somebody else who is interested on your property. That we call it as an anticipatory breach. So actual breach means it is a breach of contract, so which is going to happen on the due date. Means what happens? On 1st April, Mr. A, he is ready to hand over the property to Mr. B and collect 1 lakh rupees. Okay, but on that date, Mr. B say, no, I am not interested on your property. So I am going towards any other property. Please, you can sell your property as per your wish. Okay, so but B refused to collect his property as per the agreement. Then this kind of breach we call it as a actual breach. Okay, let me brief once the anticipatory breach and actual breach. Actual breach means if any of a person refuse to purchase the property on the due date. On the due date means 1st April, that we call it as a actual breach. Anticipatory breach means one of the person they refuse to perform their obligation before the specified date or the specified period of time, that we call it as a anticipatory breach. Okay, very easy concept. In the next session, we are going with the topic of discharge of contract, breach of contract, remedies for breach of contract. Here in this session, unit 1 get ended. Okay, so in the next session, we are going with unit 2, that is Sale of Goods Act 1930. Thank you.